All right, gearing up for your Singapore contract law exams? I get it. The sheer number of cases, doctrines, and statutes can feel like you're trying to climb a mountain. But here's the thing, revision doesn't have to be just about cramming. There's a much smarter way to prep. So let's dive into a strategic guide that will help you absolutely ace that exam. Yeah, does this feel familiar? You're staring at stacks of notes, trying to link hundreds of different cases. It is completely overwhelming. But the goal isn't to memorize every single detail. It's about turning that anxiety into focused, sharp confidence. And that is exactly what we're going to do right now. And here's the secret. Top marks don't go to the student who can just list the most cases. They go to the one with the best method. We're going to build a mental toolkit that lets you take apart any problem question the examiner can possibly throw at you. So first things first, before we even get into the specific doctrines, we've got to master the foundational toolkit. Think of these as the essential building blocks for every single argument you're going to make in your exam. Okay, first up, ratio decidendi, or just ratio. This is the absolute heart of a judgment. It's the binding legal principle. Honestly, your number one job during revision is to find this golden nugget in every single case you read. It's the whole point. Then you have obiter dicta, or obiter. These are kind of like the judge's by-the-way comments. Now, they're not legally binding, but citing a relevant obiter, that is a pro move. It tells the examiner you have a deeper, more nuanced understanding, and it can seriously bump your answer up from good to great. And how does all this work? Well, it's all built on precedent, which is the backbone of common law. A past decision acts as an authority for future ones. In your exam, citing the right precedent isn't just good, it's non-negotiable. It's how you ground your entire argument in law. The engine that drives this whole system is stare decisis, the idea that courts have to stand by decided matters. Why? To make sure our legal system is consistent, predictable, and stable. And you know what? Mentioning that little policy consideration in your analysis, that's a very smart move. Okay, toolkit's packed. Now let's build that mental map. Think of this as a high-speed tour of the key doctrines. Just treat these next few slides like they're digital flashcards, designed to lock in these core concepts for you. First up, misrepresentation. The big split you absolutely have to know is between fraudulent and innocent. So what's the difference? It's all about the maker's state of mind. Was the false statement made knowingly or maybe recklessly? That's fraud, and it opens up the big remedies, rescission and damages. Or was it made with a reasonable belief that it was true? That's innocent, or the main remedy is just rescission. Getting this right is so crucial. Next, let's talk contractual terms. Is a term a condition or a warranty? This is a massive deal in any breach of contract question. A condition is fundamental. It goes to the very root of the deal. If you breach it, the innocent party can terminate the entire contract. But a warranty, it's less central. Breach that, and you can only claim damages. The contract itself has to continue. So you see, how you classify that term decides everything. So we have the tools and we have the mental map. But how do you actually put it all together when that exam clock is ticking down? Well, you use the master key, IRAC. This framework is so powerful. It brings logic and clarity to even the most tangled, confusing problem question. Issue, rule, application, conclusion. IRAC. Seriously, don't think of this as just some helpful suggestion. This is the structure examiners are looking for. It forces you to think systematically and logically, just like a lawyer does. Let's break down each step real quick. Step 1, I for issue. Your job is to state the precise legal question. Don't be vague. A sharp, focused issue statement frames your entire analysis, and it tells the examiner right away, hey, I know what I'm talking about. Step 2, R for rule. State the relevant legal principle, and you cannot forget this, you must cite your authority. For misrepresentation in Singapore, you'd cite a case like Panatron. This proves you don't just know the law, you know where it comes from. Step 3, A for application. Now listen up, because this is where the magic happens. The A is where you earn the most marks. You have to apply that rule directly to the specific facts of the problem. Argue, analyze, bring in other cases. This is where you get to really shine. And finally, step 4, C for conclusion. Bring it all home. Give a clear, concise answer to the issue you identified right at the start. Based on your analysis, what's the likely outcome? You've got to be decisive.
So there we have it. We've covered the building blocks of the case method and the architectural plan of IRAC. See, the goal here is a total mindset shift from just passively memorizing information to actively using it like a skilled legal analyst.
If you remember only one thing from this whole explainer, please make it this. Spotting the right issues is the foundation of every single high-scoring answer. Get the issue right, and you are already halfway to a great mark. So I'll just leave you with this final thought. As you head into your exams, keep this question in your mind. Is success about simply knowing all the rules, or is it about mastering the art of the argument? Everything we've talked about today suggests it's the latter. Now go get 'em. Good luck.